Oh yes, oh yes, oh yes, the Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Tennessee Court of Appeals. Appreciate you being here this morning. We're happy to be here in person, which is something a little bit different. We'll take just a couple of minutes before we call the first case and talk about our procedure and also introduce the panel for this morning. First of all, your panel this morning will be Judge Arnold Goldin from Memphis, Judge Kenny Armstrong from Memphis, and I'm Steve Stafford from Dyersburg. I'm sure that all of you are experienced practitioners, but just again want to hit the basics. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you've come up to the podium and introduced yourself. If you are the appellant, you may reserve up to 5 minutes of rebuttal time, but that's not required. Our lighting system on the podium is what I believe to be very straightforward. It's green, yellow, and red. As long as the light's green, you got plenty of time. Once the light turns yellow, you're running out of time, and once the light is red, you are out of time. And we ask that you please respect those time constraints. We have our Chief Deputy Clerk, Ms. Angie Dempsey, with us here today. If you have any question about the record or need any guidance about procedure, you can see her at the break. I also want to remind everybody that these arguments are being live streamed over the internet. So as you are making your argument, please keep that in mind if there's something sensitive or something that should not be disclosed. Ms. Angie, anything before we call the first case?
No, Your Honor.
You may call the first case, please.
April Hawthorne versus Morgan & Morgan Nashville, PLLC, et al.
Good morning.
Good morning. I'm Tim Edwards for the appellant April Hawthorne.
Do you wish to reserve any rebuttal time?
Thank you, Your Honor. I'd like to reserve 2 minutes.
2 minutes. All right, sir. You may proceed.
Although I think I'll have plenty of time. Okay. When I was working up my outline on this case, I must confess that I had to struggle some because the error seemed so obvious to me that I really was having a difficult time figuring out what to say. The complaint, which has gone through several iterations, I think there were 2 amendments, have consistently alleged legal malpractice, breach of fiduciary duty, and some other issues, but those 2 are the gist of the complaint. So to affirm this Rule 12 dismissal, this court must find that legal malpractice and attorney breach of fiduciary duty do not state a claim upon which relief can be granted after construing the complaint in its most favorable light to the plaintiff. It was not necessary in defending this Rule 12 motion that we submit the affidavit of Bruce Kramer, which we had already done. I suspect that Your Honors know Mr. Kramer. He's an attorney of many years of practice in Memphis, and he gave us an affidavit that basically boiled down to that if the allegations of the complaint are proven, then this complaint does state a cause of action for legal malpractice and breach of fiduciary duty. That was already in the record. We had submitted that in conjunction with our motion for class certification. So the sole issue for this panel is whether legal malpractice and attorney breach of fiduciary duty states a cause of action. It's that simple. The ruling of Judge Kyle, Chancellor Kyle, says that it does not, in what was before him. This motion was but one of a number of obstructions thrown out by the defense to keep this case from pressing forward. There were motions to transfer, motions to recusal, motions to stay, and of course we had to go through COVID also, which was problems. But the case dragged on and on. We faced motion. On June 28, 2021, we appeared on defendant's motion to dismiss. Mr. Townsend had driven down from Nashville. We were in the courtroom for the plaintiff, all prepared to argue the motion. Chancellor Kyle comes from his office into the courtroom and says, I don't need to hear from anybody. Let me talk. And the gist of what he said, and this is a quote, I just don't see it. That was the sum and substance of his legal reasoning. I just don't see it. So we never had a say-so. My co-counsel, I think Mr. Townsend was as stunned as we were that this motion had been granted. My co-counsel got up and said, Chancellor, I'm not arguing with you, but I want to make sure that all you are ruling is that the complaint does not state a cause of action, because a number of issues had been raised by the defendants, collateral estoppel, lack of standing, and some other stuff. So Mr. Watson got up and got the chancellor to confirm that it was only that there was no cause of action stated, even though the complaint alleged legal malpractice and breach of attorney fiduciary duty, which does exist in Tennessee.
Mr. Edwards, is Mr. Watson your only co-counsel?
He is, Your Honor. He was at that time. I'm handling the appeal individually.
Okay, all right.
Is he still your co-counsel?
He is not, well, Mr. Watson is, let me say, he is not at this point. We have looked at, if Your Honor is raising an issue about is it appropriate for him to be in the case, we investigated that issue and decided it would be fine, but out of an abundance of caution, I am handling the appeal.
That didn't answer my question.
Okay. Is he still my co-counsel at this point? The answer is no.
Has he withdrawn as counsel for the plaintiff?
No, he is not. I think not, no.
That answers the question.
All right, so
Let me pose a question, if I might. You say, from your perspective, and I'll hear from opposing counsel as well in a moment, that the complaint was dismissed solely because it failed to state a claim. Is that accurate?
yes.
Do you have any idea of what the problem was with the complaint that rendered it a complaint that was defective?
None whatsoever. And
Was a request made to the trial court to elucidate that?
there was the exchange I just related, Your Honor, which would have been the only request as such. That was when Mr. Watson stood up and said, Your Honor, just for clarification point, I want, the court is ruling that the complaint on it does not state a claim upon which can be granted. As I said, the defendants had raised a number of other issues, and he said, I'm not ruling on any of those.
So our determination or our focus should be solely on whether under any circumstances this complaint states a claim.
That is correct, sir.
Okay.
And to go on to put a fine point on that particular issue, the chancellor, after he made this ruling of dismissal, had said that he wanted the order to be very brief and very general and not give any specifics as to the bases. Well, he didn't say that, but he said, I just want a very short order stating that what I've just said, that the complaint does not state a claim upon which relief can be granted.
And Mr. Edwards, who prepared that order?
It was prepared by, I believe, Mr. Townsend, and we signed off on it.
And the submission that was made to the trial court by Mr. Townsend, was that edited in any way?
Not that I recall, Your Honor. It was very summary, as directed by Chancellor Kyle.
Okay.
It said no more than what I've said, didn't give any legal basis for the dismissal other than the complaint did not state a claim upon which relief could be granted. My assessment of that is that Chancellor Kyle knew that this ruling was improper and wanted the order to be as general and obscure as it could be. Because had he given specifics, I think that would have made the impropriety of the order obvious, glaring. So it has no specifics, no legal reasoning contained in that order. Now, the defendants have come before this court arguing 4 points, none of which were contained in the order of the trial court or even discussed, nor was there there was no argument on these. The first is equitable estoppel. You can't grant a Rule 12 motion on equitable estoppel, even had it been argued, but it was not. That requires some facts. The second is class counsel does not have the authority to make settlements. Well, that's disingenuous because that's not our case. Our case is that the class counsel did not act in good faith in considering offers which were reasonable, nor were those offers communicated to the class, which is an ethical violation, which I understand does not standing alone constitute a basis for a legal malpractice case, but it is evidence of legal malpractice. The defendants don't, the appellees don't even address that in their brief. The third was speculative damages, which were in Chancery Court. Speculative damages have nothing to do, you can't grant a Rule 12 motion on speculative damages, but again, it was not discussed. And the damages aren't speculative anyway, as we've pointed out very clearly. And fourth, there was lack of standing, that the plaintiff did not have standing to bring this action. Well, the plaintiff was in the class that was certified in the underlying case and affirmed by this court on appeal. And so she is damaged as a member of the class. But again, none of these were even discussed. And
Were
this
all
court,
these issues raised in pleadings that were before the court at the time?
I'm sorry, sir.
Were all these issues, these 4 matters that you've listed, were they all raised in pleadings that were pending before the court at that time?
Your Honor, it's taxing my memory, but to the best of my recollection, in one submission or another, I believe that all 4 had been submitted. As part of what motion or whatever, I can't recall. That's off the top of my head. I'm pretty sure equitable estoppel and lack of I know speculative damages had been. Okay, and so this court had, in the Copper Basin case, it said that the appellate court should only address issues that were raised in the trial court. Well, none of these were raised at the time. At the time of the motion to dismiss, none of these were argued.
When you say none of these were raised, weren't they raised in the motion to dismiss and the memo in support of that motion to dismiss?
I think they are, Your Honor, yes.
Okay, all right.
Again, that's from the best of my recollection. Were all four raised? I can't swear to it, but I believe so. All right, the court, interestingly, the trial court never said that there was no duty owed to the class by the defendants, which of course is key for a legal malpractice case. The Kramer affidavit was never rebutted. It was in the record. There was never a countervailing affidavit that said that there was no breach of duty.
Did the court consider that affidavit?
Never mentioned it, Your Honor.
The reason I ask that is, are we dealing with a summary judgment issue, or are we dealing with a motion to dismiss issue?
I've asked the same thing, debated myself. I can only tell the court what was said in the courtroom. The Kramer affidavit was never mentioned by the trial court. It was on file, it was of record. It clearly stated that these facts, if proven, stated a cause of action for legal malpractice and breach of fiduciary duty.
All right, sir. You've used your initial time and you have your rebuttal time.
Thank you.
Thank you.
May I address the court concerning timing for just a moment?
I have no idea where you're going, but go ahead.
This is a matter in which I represent appellees, and there are further appellees who have a position adverse to myself. I don't want to voluntarily give up any of my time, but I want to make sure that the court is aware that if the appellees have 15 minutes, I'd like to utilize all or mostly all of it.
That's the only thing that this panel's aware of, is that you're making the argument for the appellees.
Thank you, Your Honor. I'm Darrell Townsend from Nashville. I represent the defendants. In the underlying case, the Wofford case, there were 30 individual funeral home defendants, and therefore there was one class representative as plaintiffs for claims against each of those funeral homes. That is to say, there were 32 named class representatives. Catherine Barnett, my client, was designated lead counsel, and we believe that it's important that the court understand the terms of her representation. Pursuant to an order entered by Chancellor Kyle, Catherine Barnett was designated lead counsel, and she had the authority to conduct settlement negotiations on behalf of the plaintiffs, but not enter binding agreements except to the extent expressly authorized. I'm quoting from the record, page 818. Further, the order says, counsel for plaintiffs, that is to say all of the other plaintiffs' attorneys, counsel for plaintiffs who disagree with lead counsel or who have individual or divergent positions may present written and oral arguments, conduct examination of deponents, and otherwise act separately on behalf of their clients as appropriate. Each of the plaintiffs' counsel in this case, and there were close to 10 of them, I believe, each of them had an obligation and the authority under this agreement to participate in settlement negotiations, to disagree with Ms. Barnett, and to act separately on behalf of their clients with respect to those settlement negotiations if they so chose.
Is that why you say the chancellor dismissed the complaint?
That is one of the reasons, Your Honor, and that's one of the grounds that we raised.
And how do we know what the chancellor dismissed the complaint for?
We know that he dismissed it because of the failure to state a claim, and we know that in our motion we stated 4 reasons that the complaint failed to state a claim upon which relief could be granted, and the chancellor could have relied on any or all of those. He chose simply to state that there was no cause of action based on the inferences that he drew most favorably to the plaintiffs. He did not specify the grounds for his ruling, and he was under no obligation to do so, because this was a Rule 12.026 motion to dismiss. It was not a motion for summary judgment. The chancellor did not look to matters outside the pleadings. He explicitly stated so. And the affidavit of Mr. Kramer, which Mr. Edwards has referred to, was submitted in support of a motion to certify a class. It was not submitted in opposition to the motion to dismiss, and it did not address the issues which the defendants raised in their motion to dismiss. The court can search Mr. Kramer's affidavit in vain for any attempt to rebut our arguments that there was no dutio, that damages would be speculative, that there was an estoppel to be applied. Mr. Kramer's affidavit didn't address any of those. The plaintiffs were free, once the motion to dismiss was submitted, to submit anything that they wanted in opposition to the motion. What they chose to do is rely on the allegations in their complaint. So
you're saying that as a matter of law, based upon the undisputed facts in this record, that this court can look at either equitable estoppel, lack of authority of class counsel, speculative damages, lack of standing by plaintiff, and looking at the undisputed facts, that as a matter of law, this complaint could be dismissed on any or all of those defenses?
that is absolutely correct.
Okay.
Absolutely. And the law is plain that the court can affirm a ruling of a lower court, even on issues which were not raised. If this court if an appellate court on its own determines that there are grounds for certain action by the trial court, this court can do that. So where these issues plainly were raised and the plaintiffs chose not to submit a single shred of proof in opposition, then that's the record.
Motion to dismiss, isn't it?
It is a motion to dismiss. We just went in and said, take this 78-page complaint that they have filed, look at it, grant them every inference which can be drawn from the facts which they have alleged, and we will presume to be true. They do not state a cause of action, and we set out 4 separate grounds for why there was no cause of action stated. Now,
So none of the facts are controverted.
I'm sorry, pardon me?
None of the facts as alleged by the plaintiff are controverted
None.
for any of these defenses to be applicable.
I'm sorry, I did not understand the question.
The facts as alleged by the plaintiff are taken as true.
Correct.
And for you to be successful, those facts that must be taken as true, and these defenses must apply so that you are successful.
Correct.
Okay.
And we were, and Chancellor Kyle plainly indicated that he understood the standard in his comments from the bench and in his order, and the court speaks through its written orders. He said, I have considered all of these facts and have considered them to be true, and I have granted the plaintiffs every reasonable inference to be drawn from those facts. Still, I find that there is a failure to state a claim upon which relief can be granted. Now,
Did the chancellor make that statement in his oral ruling?
he did. And I incorporated it into the order which I drew, and the plaintiff's attorneys signed off on that order, approved as to form. So, if we consider that all of these facts, these horrendous facts, which if this case were to go forward, we would dispute and disprove. But if we assume all of these horrendous facts are true, then the question is, what inferences reasonably can be drawn from those facts? Well, how do we draw inferences? How did the trial court draw inferences? We draw inferences by calling on our life experiences, the knowledge that we have acquired, the wisdom that we have acquired. We apply those things to a set of facts. In this case, what is interesting is that the trial court judge, Chancellor Kyle, was uniquely qualified to draw inferences from the facts which were presumed to be true. He was uniquely qualified because, as he said from the bench in his ruling, he had lived with this case and the underlying Wofford case since he set foot on the bench. He was the trial court judge in the Wofford case. He knew that case. He knew what was involved in that case and what the strengths and the weaknesses of the plaintiffs and the defendants were. Because he was the trial court judge, he was uniquely qualified to draw the inferences which he drew. And his inferences were that at least one of the 4 grounds raised by the defendants were good to defeat the claim and make it not state a cause of action. If I may have just a moment. And those grounds were estoppel. Succinctly stated, because the plaintiff's lawyers in the underlying case knew all that was going on with respect to settlement negotiations, offers being made, counters being made, they must be estopped, the plaintiffs themselves must be estopped from claiming that they've been damaged. And it's axiomatic, and we cited to law in our brief, that clients are barred by the knowledge of their attorneys. Well, this complaint itself says that all of these other plaintiffs' lawyers were aware of Ms. Barnett's horrendous behavior. The complaint itself says that they begged Ms. Barnett to address settlement differently. They say that they were aware of the settlement negotiations which were going on and that they were aware of Ms. Barnett refusing to negotiate in good faith. They describe Ms. Barnett as having been, and I'm quoting from their complaint, unhinged, unethical, irrational, insane. The plaintiff's other counsel witnessed this behavior on behalf of Ms. Barnett in the settlement front and did nothing. They were perfectly content to sit back and allow the settlement negotiations to be thwarted and await a big jury verdict. And when it didn't come, then and only then came the complaints about Ms. Barnett's behavior. Chancellor Kyle hit it on the head. He hit the nail on the head in his comments from the bench in ruling on the plaintiff's complaint. He described it as Monday morning quarterbacking. That's precisely what we have here. That's precisely what the chancellor saw in the facts alleged in the complaint, and his conclusion reasonably could have been, and this court reasonably could conclude, that the plaintiffs, by virtue of the actions and inactions of their counsel in the underlying Wofford case, are barred from making claims against Ms. Barnett. This case comes to the court from Chancery Court. This was a choice made by the plaintiffs. They amended their complaint after it was filed to assert that their claims were liquidated so that they could keep the jurisdiction of Chancery Court and so that they could keep Chancellor Kyle as the judge. We attempted to have it removed to Circuit Court because we believe it is not a liquidated damages claim. We failed on that issue. So when the motion to dismiss came on, it came on for hearing before the Chancellor, the judge of the plaintiff's choice. As such, and because this was the plaintiff's forum choice, certain equity principles apply, and we have cited them in our brief. A party cannot set up claims inconsistent with his acts and his words or his silence, and that's exactly what the plaintiffs are trying to do here. They're setting up claims which are inconsistent with the behavior of their attorneys in the underlying action. Now, secondly, we asserted that the complaint failed to state a claim because Catherine Barnett did not have the authority to settle claims. Catherine Barnett had the authority to conduct settlement negotiations, but she was specifically barred from making binding agreements except to the extent expressly authorized.
And by authorized, you mean approved by the trial court?
Yes.
Did she have an obligation, though, to communicate settlement offers to members of the class or the class representative?
No, she had an obligation to communicate with other plaintiffs' counsel who all had their individual clients. And the complaint makes plain, Judge Armstrong, the complaint makes plain that these plaintiffs' lawyers were aware of what was happening on the settlement front, that they were aware that settlement offers had been made that should have been accepted, and that Ms. Barnett crazily rejected them. So the plaintiffs, their representatives, their lawyers were certainly aware by the own words in their own complaint of what was going on. So even if Ms. Barnett had recommended the settlement that after the fact the plaintiffs say should have been made, even if that is accepted, then what would have had to happen? Well, Ms. Barnett would have had to approve. It would have had to go before the chancellor. There would have had to be a hearing. There would have been an opportunity for plaintiffs to opt out. There are all of these steps that have to be taken in order to actually effectuate a settlement which Ms. Barnett did not have the authority unilaterally to do. Therefore, it's plain as the nose on your face that any claim for damages in this case would be unnecessarily speculative. That was another of our arguments.
Counsel, wouldn't the floor in terms of damages be at least the offer that was made and then just refused?
Respectfully, I don't think so, Judge, because the offer itself, again, would have had to have been approved by the chancellor, found to be in the best interest of the class plaintiffs, and there's a reasonable possibility that that wouldn't happen because, and I see I'm running out of time, so I'll finish on this thought, because the plaintiffs have said that each of these non-settling defendants made or would have made, somehow they know, would have made an offer of $15,000 per body. And those should have been the settlement terms.
Well, didn't the trial court later accept a settlement for less than the amount that was offered?
Yes.
And rejected and not communicated by your client?
No, the court accepted settlements which were negotiated by another plaintiff's attorney after the result in the trial court, after the jury verdict in the judgment of the trial court.
But the amount approved by the trial court was less than the offer
It
that was made.
It was. And that probably was reasonable because by that time the trial had been had, the results had been poor for the plaintiffs, and so it would have been reasonable to settle on a nominal basis against the possibility of an appeal. But Ms. Barnett's behavior can't be judged against what was done after the fact, after the trial and those settlement negotiations were made. But what shows the speculativeness of this claim is what settlements actually did occur before the jury verdict. And I'll finish up. I realize I'm over my time. One funeral home settled for $25,477 per body. That's the way that these claims were settled, per body that a funeral home had. $25,477. They got the $4 million policy limits from that funeral home. Another settled for $50,000 per body. And during trial, while the jury was actually deliberating, a third funeral home defendant settled for $75,000 per body. Now, if those were reasonable settlements, would the trial court judge have approved these nominal settlements of $15,000 per body, which the plaintiffs say Ms. Barnett should have jumped on?
You used your time.
Thank you, Your
Am I out, Your Honor, because we had this third party?
I don't know anything about a third party.
You know?
No, nobody's asked to make any oral argument, so we're proceeding with
I see.
appellee and appellant.
The answer to Your Honor's question about damages is yes. The amount of the offers which were rejected would establish a firm figure in the base for the damages calculation in this case. What I've heard is nothing but argument of facts which were not before the court. What was before the court was pleadings, and none of the four bases, once again, to be redundant, were argued by the court. What is being ignored by Mr. Townsend in his argument is that Ms. Barnett was sole class counsel. She was counsel for the class. The other lawyers may have had individual clients which were subsumed by the class.
Let me stop you and ask you a question. What
Yes.
exactly does that mean?
What it means is that she is the attorney that owes a duty to the collective, to the cohort of persons in the class. She is the sole person. Otherwise, Your Honor, you would have chaos, because in every class action that I'm aware of, you have individual lawyers with a limited number of cases. It is not feasible to try to prosecute each one of those cases. So that's the reason for a class, to give there some order to masses of claims. In order to...
Well, let me be more specific
Yes,
in my
sir.
question.
Go ahead.
Assume that the members of the class are dissatisfied with what class counsel is doing, the attorneys representing the respective parties. What was there in this situation, a written agreement, or is there something that defines what those rights and duties are of the respective counsel?
Understood. No, there's, the law sets that forth, Rule 23, Tennessee Rule 23, Federal Rule 23.
So there was no other
class
written
action.
agreement?
There's no agreement.
Okay.
In every case, the rule, the law requires that the trial court appoint lead counsel, so you don't have all of this chaos. And Your Honor asked about, I believe asked about,
If there is a disagreement.
okay, I've been in that situation. You send out notice. What is done is all the class members are notified, because this was what's known as an opt-out class. They could opt out. And so notice is sent out of a proposed settlement. And I had one in Arkansas where somebody dissented. They came into court with their own counsel and contested the settlement. The trial judge, a federal judge in that case, listened to the objections and overruled and approved the settlement. And I might add that,
Well, let's talk about this case.
okay, this case,
Let me ask you a question about that, because I have some question about that as well. Are you saying that none of the other class counsel that represented the other parties, this group of lawyers, had any obligation, if they thought that these were reasonable offers that were being presented, that they had any obligation to, and they disagreed with Ms. Barnett, to come to the court and say, we've got this offer, Ms. Barnett's refusing to negotiate, we think it's a reasonable offer, we want to bring it to the court's attention? No obligation to do that?
there is no obligation for any lawyer to address the court on settlement other than lead counsel. That's the way it works. What was misrepresented was that these individual lawyers were clamoring with Ms. Barnett, accept these offers, because you see, they knew what the insurance coverage was for each defendant in that underlying case.
But my question, though, is, are you saying that they could not petition the court about the conduct of Ms. Barnett and present the court with these offers that, and if the conduct was so egregious that they could not petition the court to step in and either have her removed, which is what ultimately happened, or to address these settlement offers that at the time, apparently, in retrospect, you now think were reasonable?
I mean, could they do it? Theoretically, they could do it.
I mean, as a matter of class action law, you can do it, can't you?
I don't think so. No, once lead counsel is appointed, lead counsel has the responsibility to the class. They were arguing with Ms. Barnett over whether she should take those, and she was threatening them to walk out of the case, to withdraw her 500 clients, because they had amassed these clients through advertising. And she was going to withdraw her 500 persons that she brought to the
Could
class.
she do that without the court's approval?
She could withdraw it. So the court didn't have to, all the court has to approve is settlements.
But there was a class at that point. The court, you can't just remove people from the class without the court's approval. Nobody went to the court. That's the part I don't understand. All of this is now happening, but at the time that it was happening, all these lawyers were there, and they didn't like what was going on, but they didn't do anything about it. That's a fair assessment?
I know, Your Honor, respectfully, no. They were working as a group trying to convince Ms. Barnett, because again, they knew what the insurance coverage was because there had been DJ actions in federal court. All those policies had been produced. They knew that what she was doing was acting for self-aggrandizement because she had gotten some large settlements, all of which had been approved, and she was trying to, those had set a standard for her as to every defendant. But as Your Honor.
That's okay. Thank you.
Okay.
Thank you. Thank you, counsel. We'll take this matter under advisement, and we'll attempt to render a decision at the earliest possible time. You may call the next case, Ms. Angie.
Lisa Neely Autry